I think it's important that we look at the origins of the Cybercrime Act, and this is the international treaty. The first treaty on this was back in 2001. It was the Budapest Treaty, and that wasn't a treaty actually. It was a convention on cybercrime. And that convention, and I forgive me for going through this in detail, but I think people should know this, dealt with literally 5 areas. It was illegal access to a computer, illegal interception of information, data interference, system interference, and misuse of devices. Under the heading misuse of devices, it had absolutely nothing to do with the issue of defamation. What the present government is attempting to do is to criminalize defamation. Defamation allows you a civil remedy. So if someone libels you or defames you, you're entitled to go to court and get damages. What the present government is doing is giving a criminal sanction to what in effect was a civil wrong, which you had to go to court. The problem with that is that it now becomes a tool in the arm of the state that will be used to prosecute, stifle, and silence people the government want to get rid of. And there's no better case that I can refer to than the case of Sherod Duncan. Why would you want to criminalize somebody because they went to social media and called you a trench crapo? If you are offended by that term, the law provides you with a civil remedy. You sue the person. You sue the person. You bring an action for defamation. But to make that criminal, it means now, one, it gives the prosecution of any of these offenses under the existing legislation a very wide discretion to prosecute anybody. And invariably, this has always been used, as we've seen recently, only to silence people who either criticize the government or criticize the police force. We've had a series of charges against Dion Bascom. We have seen what has happened to Sherod Duncan. And in essence, they have now criminalized what for centuries has been a civil wrong. There are very few countries in the world that seek to silence their citizens because they seek to defame. If someone defames you, the appropriate remedy lies in a suit for damages. It doesn't lie in giving the prosecution and the Guyana Police Force, which I just said enjoys an exceedingly sterling reputation, the power to be able to prosecute someone, even if they may not be successful, from the time the arrest and the trauma that person goes through before they get acquitted. They have to spend significant resources, they have to go to court, and they have to suffer the public humiliation of having been charged. So particularly in the light of what has happened under the Cybercrime Act, the way in which it has been deployed, or the prosecution of people by the state has been used, we have very grave reservations, very, very grave reservations about anything looking like an expansion of the cybercrime bill. I believe during the previous administration, when the bill was actually passed, there was strong internal criticism about it. And we believe, and we've expressed this before, that the time has come to repeal several aspects, particularly Section 19 of the cybercrime bill. Any expansion now is a grave potential trespass on the rights guaranteed under the Constitution to its citizens, and in keeping with the thrust of the Budapest Convention from 2001, we believe it should be limited to those areas. It should not be used to prosecute defamation. The other difficulty with Guyana is that given our very, very fragile and fractured state here, anybody that says anything that may remotely be interpreted as causing concern can find themselves charged for cybercrime because it's very subjective to the victim and does not provide the protections to the of fair trial and due process to the persons who are charged.